Okay, Judge Shapiro, we have everybody available. I'm going to have to ask you to turn your video back on when you're ready, and I can bring them in when you're ready.
Okay. Wait a minute, has asked you to start your video. Okay. No.
And we have a number of them, so it might take a couple minutes for them to filter in.
Okay, no problem.
I just want to let you know, we also have a Bayan Jaber who is in the attendee room, but I don't have them listed as an attorney, if they should be coming in or not.
Who is that?
She's an attorney with Pitt McGee, and she will be one of the presenters today.
Oh,
Okay.
well, that's fine.
Everybody's present.
Very good. Thank you, Morgan. All right. Well, I'm going to call the case of Bauserman and Bro individually and on behalf of a class versus State of Michigan Unemployment Insurance Agency, Court of Claims, docket number 2015-202-MM. And we're here today for review of several orders related to the proposed settlement agreement. And who will be speaking. And well, first of all, let's get everybody to put their appearance on the record. So since everybody's here, let's start with the plaintiffs.
Good morning, Judge. Michael Pitt on behalf of class.
Jennifer Lord on
Rivers on behalf of the class, Your Honor.
All right, so we have Ms. Lord, Ms. Rivers, Mr. Pitt. Anybody else on behalf of the plaintiff class?
Kevin Carlson, also on behalf of the plaintiff class, Your Honor.
All right, welcome. And then we have two, I think, for the defense, if you put your appearance.
Yes, good morning, Your Honor. Assistant Attorney General Debbie Taylor representing the Unemployment Insurance Agency. My colleague, Jason Hawkins, will not be attending today.
Okay, very good.
Your Honor,
and then yes,
we're also appearing on behalf of the class.
Also be here on behalf of the class?
Yes.
Very good. Let me turn my volume up.
And I'm sorry, so Miss, is it pronounced Yaber? Do you have it? Did you file an appearance? Because I didn't receive anything.
Jaber, no, I haven't filed an appearance yet. I will do so soon. Thanks.
All right, very good. Who will speak initially for the plaintiff?
Beth, did you say hello? Beth?
I'm sorry, yes?
Beth Rivers, did you identify yourself?
Yes, I did.
Oh, okay, I didn't hear you. Your Honor, we're going to do a teamwork, some teamwork here.
Okay.
And we prepared a PowerPoint to guide us in our discussions. Hopefully this will make the discussion go more efficiently. So
okay.
Dan,
I reviewed everything, by the way, but yeah. Feel free.
Dan, I'm going to put up we'll start with the table of contents.
Okay.
So there are 12 segments to what we're going to present to the court today. This follows the brief that we filed, and members of the plaintiff's counsel will handle certain segments. I'm going to start off with the settlement agreement and explain to the court why the settlement agreement should be approved as fair, reasonable, adequate, and in the best interests of the class.
Right.
So, by way of background, the case, as you know, it was at the Michigan Supreme Court on 2 occasions. The first trip involved the question of notice. And the Michigan Supreme Court made a very significant ruling that is guiding us today in terms of which class members have timely claims that can be a source of recovery in this proceeding. The second trip to the Michigan Supreme Court involved the existence of the constitutional right to damages against the state under the Michigan Constitution. While the case was pending for the Supreme Court on the constitutional tort issue, the parties began talking about possible resolution. That was in July of 2021. We quickly decided that Megan Norris would be a more than satisfactory mediator. We knew that we needed somebody who had a firm, she's from Miller Canfield, Your Honor, that could help the parties digest the data that was coming from the agency that would help us sort through who is properly in the class, who is not properly in the class, the amount of their economic losses, and the existence of any refund that they may have received from the state during a period of time when the state was refunding some of the economic losses. So from July 21 until September 27, we had numerous meetings with the mediator. The mediator received significant volumes of information from the agency. There was cooperation among all counsel, and Ms. Norris was able to sort through the vast amount of data and come up with a pretty good estimate of who is in the class. And the Michigan Supreme Court said that only people who had a first collection after March 9, 2015 would have timely claims. So she sorted through all the data, and her team came up with a list of 8,186 people. We're still working on the list. If the court does approve the settlement, notice will have to go out around the 1st of February. I think we have time left to debug the list to make sure it is as accurate as it could possibly be. Unfortunately, based on the Supreme Court ruling, claimants with wrongful collections occurring before March 9, 2015 will not be eligible to participate in the settlement because their claims will be considered untimely. When we received the class lists, we did retain our own expert to help us do an analysis to make sure the data seemed logical and helped us do some calculations as to what the value of the settlement should be. Negotiation on the appropriate settlement amount began in August of this year. These negotiations were arm's length and vigorous. There were a series of demands and counters, resulting in a mediator recommendation of $20 million on September 27. Both parties accepted the mediator recommendation. As you can see from the PowerPoint that's on the screen, shortly after we reached settlement, the legislature of the state of Michigan approved the settlement. Settlement funds were earmarked and allocated. Shortly thereafter, the $20 million was sent to our office, where we held it in our IOTA account until a QSF, Qualified Settlement Fund, could be establish, and the money has been transferred to the Qualified Settlement Fund Administrator, and the money is currently being held by Huntington National Bank at interest rates approaching 4%. Since it's unlikely that the distributions will occur before September of this year, we're hopeful that the money in the bank will generate significant additional money for distribution to the class. So, the settlement agreement is fair and reasonable because from our examination of the economic losses of the 8,186 people, we believe that there is more than sufficient amounts of money to compensate most people for 100% or close to 100% of their economic losses. We computed the economic losses of this group to be $8,854,713. So if the court were to approve our request for attorney fees, which would be 1/3 of the aggregate amount that we were able to collect for the class, there would be approximately $12 million left for distribution to the class. As you'll see later on, we're proposing to put $8 million into the economic loss pool and $4 million in a hardship pool. So we feel very confident that even if the court grants our request for attorney fees at 1/3, most of the claimants will receive close to 100% of their economic losses. That, of course, will depend on the number of claimants. If there are more claimants than we know about, which is a possibility, then the share of each class member may be diminished by a certain amount of percentage points. Megan Norris has agreed to be the special master. The settlement agreement provides that eligibility for the participation in the compensation plan will be based on whether the individual appears on the class list. If that person is on the class list and they agree to the amount of money that the state shows as having been wrongfully collected, then the class member has nothing else to do except express approval for the amounts. If there are individuals who are not on the list but believe they are eligible, there is a due process program that we've adopted that allows them to establish their eligibility. And if somebody is eligible but disagrees with the amount that is shown on the class list as to their economic losses, there's a due process program in place to allow them to establish what they believe to be the correct amount of their economic losses. The state has agreed to provide us with a liaison person if there are eligibility disputes or disputes about the amount of the wrongful collection. Then we can do a deeper dive into the state's databases to assist the class member in establishing his or her eligibility or claim. There is a walkaway right, as you can see, of 10%.
Mhm.
It's about 810 people thereabouts. We are class counsel are fairly certain that, given the nature of the settlement and the fact that most people, when they understand what the settlement is going about, will gladly welcome the opportunity to be finally compensated for what happened to them after 7 years. And we have reason to believe that the walkaway rights will not be triggered in this case. Finally, Your Honor, you will retain jurisdiction over the settlement for the parties' agreement. If issues come up that require interpretation of the settlement agreement, or if there are unanticipated issues that need the court's attention, the parties have agreed to bring that to your attention, and we believe for the protection of the class, court supervision is a fundamental requirement of this settlement. So we also established, as you'll hear about later, a fund for hardship claims, individuals who had bankruptcies, lost jobs, a number of adverse events that occurred to them that were related to the wrongful collection. They will have an opportunity to present a claim and receive compensation from the hardship fund, which we've pegged at $4 million. We believe that that's going to be an adequate amount to compensate people. There's a pour over function. So if we have, if we only use 6 million of the 8 million in the economic loss pool, 2 million will pour over into the hardship fund, and allowing for greater recoveries for those claimants who can establish the hardship eligibility. So unless the court has any question, we would ask that the court approve the settlement as fair, reasonable, adequate, and in the best interest of the class.
I have two questions, and the quick comment, which is, I had anticipated conducting this on my computer here at the Hall of Justice, and unfortunately I'm having a problem. So you're on my iPad, and my iPad is running out of juice. So after I ask these two questions, I'm going to pause for a moment and see if somebody can get me something to plug into, okay?
Okay.
All right, so Mr. Pitt, is the attorney fee gross or net after costs, the percentage derived from?
Yeah, well, Miss Lord is going to present that to you shortly.
Okay. All right.
But it's basically 1/3 of the net recovery. I mean, the settlement agreement does provide for $1.5 million set aside for administrative costs. We don't believe we're going to get anywhere near that. I think that was probably an overestimation. But whatever we don't use for administrative costs, we'll go right back to the class.
Okay.
So that, but we think that the administrative costs will be less than $500,000. We have the claims administrator has given us a quote which is quite reasonable, and the special master, she of course will be paid, and she's going to have a lot of duties. She's going to handle appeals. She's basically the due process department, and so when somebody is aggrieved by the process, they can go to her, and of course she will be sending us invoices, or sending the class invoices for her time. So,
all right, and Ms. Taylor, are you there?
Yes, Your Honor, I am.
Do you dispute, or do you agree with Mr. Pitt's description of the settlement even after attorney fees, as able to provide nearly 100% of what are in good faith believed to be the claim losses?
Your Honor, I do. We spent a lot of time, as Mr. Pitt has indicated, with the mediator. So I believe everything that Michael has indicated is true and accurate. And I believe, as Michael does, and the Pitt team, that the settlement is reasonable.
All right. Why don't we proceed to the next person? I don't see any reason not to approve the settlement as drafted, but we'll go through everything and then I'll advise on all of them.
Hey, Megan, you want to go to the next slide?
Yes, and if I should get cut off, hang in there and we'll get everybody back. You're muted, Mr. Carlson.
You could catch. Kevin Carlson on behalf of the plaintiff class, Your Honor. Class certification is governed by MCR 3501. And there are 5 familiar categories that the court has to analyze, which are numerosity, commonality, typicality, adequacy, and superiority. As we go through these categories, and this is indicated in the case law, and it's somewhat intuitive from the nature of the rule itself, there's a lot of merger and overlap among the categories, and I'll summarize under certain categories so as to not repeat myself as best as possible. Numerosity is easily satisfied here, Your Honor. We have 8,186 potential class members. And the key rubric, as indicated in the case law, we cite in our brief, is whether resolution of the case through one lawsuit, which we have here, and possible class certification, is more practicable than joinder of 8,186 separate lawsuits.
What makes you say that? No, I'm kidding. Sorry.
That's exactly the case here, Your Honor. A single class action lawsuit can resolve all the same issues of fact and law without filing and joining nearly 8,200 of them together. So numerosity is satisfied. Commonality, the common issue of fact and law here is a taking of property from each member of the plaintiff class without due process. And the test under the court rule is whether there's a common issue of fact or law that predominates over individualized questions of fact or law. The key finding in the Court of Claims, the Court of Appeals, and in the Supreme Court in this case is that the UIA, the defendant, was alleged to have used a single fraud detection system that flagged people and took their property without regard for any individualized facts or evidence. And so this case is uniquely well suited on its facts for a finding of commonality. There may be some slight variation among the potential class members in terms of damages, but the law is clear that the amount of damages need not be uniform. And the case that we cite for that is Hill versus City of Warren, 276 Mishap 299, which is a published 2007 decision. Damages are also readily ascertainable through the records and data that's been produced by the UIA through the mediator, and that those damages amounts are in the databases maintained by UIA and now disclosed to Megan Norris, who was our mediator and will be our special master. The variation in those readily ascertainable damages is relatively low. Damage awards range from a couple $100 to a couple $1,000 per plaintiff, more or less. And so there's nothing there that would impede a finding of commonality. Typicality generally merges with commonality, but it adds the wrinkle of asking whether the class members, who are Teddy Bro and Grant Bauserman, have claims that are typical of their fellow class members. In this case, the claims are identical, and so typicality is satisfied. The key inquiry in the case law is whether they share a essential characteristics. So purely identical claims are not required. Common essential characteristics is what's required. I think we get a lot closer here to having virtually identical claims among the named class reps and the potential class members. Adequacy inquires into the suitability and fitness of both the class reps and their retained counsel. And the test is whether they will vigorously pursue the rights of the class through qualified counsel. In this case, we have the benefit of a 7-year record, a track record where the class members have demonstrated over a long period of litigation that they are attentive to the case, they are responsive to inquiries and the demands placed upon them as class reps. They've stayed in the case. Mr. Bro and Mr. Bauserman have stayed in the case, and they've fulfilled all responsibilities that could be asked of them as class representatives. As for counsel, they retained our law firm, which possesses decades of experience litigating, trying, and resolving complex class action cases, including the Flint water crisis, multiple class action cases involving the Michigan Department of Corrections, and also private civil rights cases with defendants and large employers like Ford Motor Company and DTE. I think it's also beneficial for the court to acknowledge that we have a record already developed in this case of counsel doing a lot of diligent and high-level work to prepare this case for class certification, class-wide settlement, and claims administration, including finding and engaging a qualified settlement fund administrator, finding and working closely with the claims administrator, and finding and working closely with the mediator to make sure that
Carlson, can you
Yeah.
hold 1 minute? I'm going to try and adjust my my power problem. Hold on.
No problem. Yep.
All right, the problem appears to be solved. Hopefully it is, and we can proceed. Go ahead, Mr. Carlson.
Okay, Your Honor, I'll just wrap up on the adequacy element. It's already been demonstrated in this case that both class reps and their counsel are adequate and will serve the best interest of the class and the claims administration process, as demonstrated by all the effort that's taken place in a relatively short period of time over the last 4 months or so to get this matter fully prepared for certification, settlement, and claims administration so it can be resolved. Superiority, Your Honor, the last 3501 factor weighs the costs and benefits of class settlement against non-certification. And the key factor is whether, as we have here, the class settlement will allow each and every class member to obtain a recovery without having to file individual cases. And while the aggregated class recovery here is very large, many millions of dollars, the individual share that any one class member might get on their own would be quickly outweighed by the costs and burdens of filing their own lawsuit. To the extent that it's very unlikely that any of the individual class members on their own could afford to file individual cases to recover their individual damages. And so the class settlement process offers a vastly superior option than that individualized piecemeal approach, which would probably dissuade people from getting any justice at all. Whereas the class settlement process will facilitate everyone obtaining some redress for their injuries. Appointment of class reps and appointment of class counsel, Your Honor, is the next factor. And I don't think there's any need to repeat ourselves here. It's fully briefed. It overlaps completely with the adequacy component of 3501 identified above. And for those reasons, we would request that the court certify a settlement class and appoint Mr. Bauserman and Mr. Bro as class reps, and appoint the law firm of Pitt, McGee, Palmer, Bonatti, and Reverse as class counsel.
Ms. Taylor, do you have any response? Well,
Sorry, Your Honor, I have a hard time finding the mute button here on this one. So no, I don't. I don't dispute anything that the plaintiffs have stated. They've, as far as I can see from the presentation and the motion, they meet all the elements for class certification under the appropriate court rule, and I would agree with the relief requested.
thank you. All right, I guess is the next item appointment of special master, or did I miss something? I'm sorry, someone. We go.
Your Honor, the next topic is approval of the notice and the notification process telling the class members about the case. And we'll go through the notice first. It's at Exhibit 4 of the brief. And I would like to note that we did see a couple typos in our review, and we will correct those. Most importantly, the email for the Court of Claims clerk. And the other typo is we appear to have two different dates for the your signing of the order approving, if indeed you're going to do that. We have January 18th and January 19th, and my recollection is that January 19th was the better date for you at a prior status conference. So
That's correct.
okay. And of course, we will do a final edit and look for any other issues and make those corrections before the notice goes out. So under Michigan law.
I'm sorry, Ms. Rivers, when you said there are a couple of typos, is this in the notice or in the settlement agreement?
It's in the notice, the proposed notice, which is attached as Exhibit 4.
Got
To
it.
the
Thank
Notice is also governed by the Michigan court rules. It's 3.501C. And the notice that was developed in this case is consistent with the requirements of that rule. And we sought the help of an expert who's our claims administrator, Analytics LLC, in reviewing the notice, particularly to make sure it's in plain English and will be understood by the class members. The court rules require a description of the action, which is included in the notice, their right to exclude themselves from the case, the financial consequences for the class, that they'll be bound by the judgment, that they're allowed to intervene, and the addresses of counsel. I realize that the notice is long, it's 9 pages, but it was important to provide a lot of information to the class in easily understood English. And in fact, we attempted to repeat the important information several times throughout the notice so that they could find the information they needed. It also includes a timeline of all the important dates at the end. So I think that it meets all the requirements of the case law and the court rules, and we would ask the court to approve the notice subject to the corrections of the typos. We also created a method of notification, which is also governed by the court rules, and that is that it be reasonable in this case, because we know the identity of all class members. We expect to be able to reach the vast majority of class members. Again, we utilized our expert claims administrator, Analytics LLC, to develop a notice process. And if you review the affidavit of Richard Simmons, particularly at paragraph 16 through 37, you can get an understanding of how we developed our notification process. We are going to notify the class with direct mail by addresses which were provided by the defendant after subjecting them to the United States Post Office for correction and any verification. We also have email addresses provided by the state. And after verification, we will also notify all putative class members by email. We are going to use targeted ads on social media. We have created a website and a telephone hotline. And through all of these elements, we expect to be able to reach all class members. So we're very hopeful that everybody will know about the case and have the opportunity to make decisions as to whether to participate.
All right, thank you. What are we on to next? I'm sorry, go ahead.
So with respect to appointment of analytics consulting as the claims and notice administrator, this has been previously mentioned, but first and foremost, this court has already approved analytics as the QSF administrator. With respect to choosing amongst the options that class counsel had, class counsel interviewed 2 claims administrators and selected what they felt was the most effective and cost efficient, which was of course analytics consulting, because it satisfied counsel's requirements with respect to professional experience and proficiency and being able to fulfill all duties of both the claims administrator and the notice administrator, but importantly, at a cost that prioritized fairness to the class and maximized the pot available to the settlement class for recovery. The president of Analytics Consulting, Richard Simmons, possesses 32 years of class action consulting practice experience, and Simmons himself has personally overseen court-ordered class and collective notice programs for more than 2,500 matters. The firm was founded in 1972, and so it's believed to be one of the oldest firms offering this service in the country. And it offers services to the federal government, corporations, and both plaintiff and defense firms across an array of litigation areas, including civil rights, consumer fraud, employment, and data breach. As was previously mentioned, Simmons has proposed a robust campaign using state-of-the-art technology and a team of first-rate senior claims administrators with whom he has personally worked for years. And class counsel rests assured that analytics will deliver efficient, correct, and prompt services for the class with respect to both notice and claims administration. And lastly, continuity of claims is ensured here because unlike other claims administrators who have claims examiners overseas, Analytics actually has all of their claims examiners in-house in Minnesota, I think quite literally in the same building. And so that aspect is ensured as well.
All right, I'm sorry, whoever just spoke, you're not up on the screen, so could you just identify yourself?
Right, that's because I'm the one sharing my screen. My name is Bayan Jaber. I'm a
Okay. Very good. And Ms. Taylor, anything you want to say about the last 2 statements, Ms. Rivers, and what we just heard?
Yeah, thank you, Your Honor, for the opportunity. I don't have any concerns. I've reviewed the notice. Michael and I have worked together, he's provided me with all these documents. I had the opportunity to review these notices. I had no problem with the analytics consulting being appointed, so I have no issues here whatsoever.
All right. Excellent. All right. Who else or what else will we next hear? Allocate.
Yeah, Your Honor, this is the plan of allocation.
Mm-hmm.
And you know, first of all, let me say that we believe that it is simple and understandable and will be fully utilized by the class. The anchor piece of it is the class list. And as I mentioned earlier, once the class list is perfected, we will know who the class members are based on the agency database. Once a class member receives the notice, the first step will be for them to make contact with the claims administrator and make a simple inquiry, am I on the list? And they'll have to file a simple registration form. And if the answer is yes, you're on the list, then they're eligible. And then they will be informed as to what the state of Michigan reports as the amount of the wrongful collection. And if the claimant agrees with that assertion by the state, then the claimant's job is done. I mean, all they have to do is raise their hand and say, I want in, and there's no further process that the class member has to go through. There's no additional documentation. There's no searching bank records. Everything is cut and dried for that group. And we're really hopeful that the vast majority of the people who respond to the class notice will be treated in that fashion. However, you know, we do know that there will be people who may be unhappy with the fact that the Supreme Court has said that their claim was untimely, and they may disagree with that. So we've built into the plan of allocation a eligibility process for people who are not on the list but believe they should be on the list. And there's 2 stages of appeals. They will appeal to the claims administrator. If the claims administrator gives them an unfavorable ruling, they can then take it to special master. We have built into the plan of allocation that somebody claiming eligibility and they're not on the class list, they have to establish their eligibility by clear and convincing evidence, which we defined as some form of documentation that was generated contemporaneous with the events going back to 2015 or whenever the alleged wrongful collection took place. We do that because we want to preserve the assets for the class members who are truly class members. We don't believe there's going to be fraud, but there are going to be people who will assert that they are eligible but can't prove it. I think it's a fair burden that we placed on individuals who are not on the class list. Once they're eligible and they're satisfied with the amount that is shown on the class list as to what their economic losses are, they may, if they wish, file a second claim for hardship. The hardship fund is going to be based on points. Points will be awarded to the claimant if the wrongful collection was a contributing factor to certain adverse events. Now, class counsel gave this a lot of thought. We did not want to require somebody to prove that the adverse event was directly because of the wrongful collection. We know that life is very complicated, especially for people who are struggling financially, and so the burden of proof is pretty lax. All they have to do is establish that the wrongful collection was a contributing factor to the adverse event. And the adverse events that they can receive points for will be bankruptcy, eviction, foreclosure, repossession of personal property, credit rating decline, mental health treatment, mental health impact, loan declinations, job loss, divorce, impairment of family relationships, or other similar adverse life events. The claims administrator will handle the economic loss part of the process. That's fairly, as I said, fairly cut and dried. Class counsel will take on the burden of evaluating the hardship claims. We believe that this is the role of class counsel to sort through some of the more complicated issues that people may present as part of their hardship claims. The settlement agreement and the plan of allocation allows us to retain subject matter experts. I am not an expert in bankruptcy, but I know a lot of attorneys who are, and so we may ask, an attorney to come in and evaluate the bankruptcy claim. We think there are going to be a number of bankruptcy claims, and we want to make sure that we understand the bankruptcy process adequately to make a fair assessment as to whether somebody's wrongful collection was a contributing factor to that unfortunate event in their lives. We have attached to the plan of allocation a series of questionnaires that will guide the class member and to what information we feel is important. The questionnaire gives the class member an opportunity to present a narrative so that they can, make their case directly to us. Those documents will be available on the website, and they can either electronically fill in the questionnaire, or they can pull a hard copy and print it out and type it up or handwrite it. The claims administrator is going to receive all of the hardship questionnaires, help us sort through them, but a team of lawyers in my office will be doing the evaluation with the assistance of the claims administrator. Every step of the way, there is appeals. If, in the hardship matter, if somebody submits something and we see that they have at least a colorable claim, but they need some documentation to support their claim, they'll receive a deficiency notice from us. They'll be given 30 days to correct the deficiency. If they disagree with our assessment, they can appeal it to the special master. So we've taken great care to make sure everybody's due process rights are protected. We think it's a very workable plan. We had to invent it based on what we had, and we spent a lot of time going back and forth. We reviewed it with Mr. Simmons, the claims administrator, who has had decades of experience, and we asked Richard, you think this is going to work? And he was very pleased with it. And he thinks it's a very workable claims process, and he supports it 100%. So we think it's simple enough for most people, and we believe that it's fair and reasonable, and that people will have a fair chance to get the appropriate compensation from the settlement.
All right, my only question, and this probably stems from inexperience, is do you have any concerns, or have you considered whether there's any issues about your law firm making these determinations, as opposed to some neutral actor. Although, yeah, I don't really know if this is typical in class actions, if this is unusual, or I guess I'd like to know.
Yeah, well, we've done it in other cases. Yeah, you're right. I mean, there could be an argument made by somebody that we're showing favoritism. But I don't think it's a concern, but I don't think it is something that is an obstacle to us doing this. But I think the court raises a good question, and if the court thinks that neutral, first of all, we think that attorneys, especially attorneys here in Michigan, are the appropriate body, if you will, to do the evaluation of the hardship claims, as opposed to somebody in Minnesota who doesn't really know what's going on here in Michigan. So whether or not it's our attorney, we as class counsel who won't be charging, I mean, will be part of our fee, of course, if we have to go out and hire attorneys to do it, which we can do. I mean, there are qualified people out there who will do it. We would have to, use class funds to make that happen.
And then remind me, if someone is displeased with the amount of money they get, they can appeal. They're allocated, I should say. Then they can appeal that to whom?
Right, to Megan Norris.
Okay.
So yeah, they're under the hardship fund. They're going to get points.
Right.
And then the points are going to be, the value of the points are going to be determined by dividing the total number of points into the available funds, and then it establishes the value of a point. And so somebody may get 2 points as their award, and they may feel they're entitled to 4 points. And they will be able to make their case to Megan Norris saying, I was shorted 2 points, and give me 2 more.
And who makes the determination whether or not there has to be pour over into the hardship pool?
Well, I think that we'll, once the opt-outs are done with, so we know who's opted out and we know who's in, there's going to be, I think probably a 30 to 60 day window where people can challenge eligibility or the amounts. And once those appeals are done, we're going to know exactly how much the economic pool has to pay out on claims.
All right, and then the whatever remains can be poured over, is what you're saying.
Exactly.
All right, I misunderstood. Very good. All right, Ms. Taylor, any comments from you on this stuff?
No, Your Honor. I've reviewed the proposed plan of allocation Exhibit 5, and everything that Mr. Pitt has pointed out seems reasonable to me, and I have no objection.
All right. Any other requests to be heard? Yes. Okay.
Good morning, Your Honor. Jennifer
Morning, Ms.
Lord
Lord.
here. I would just like to follow up on something that you and Mr. Pitt were discussing a minute ago, and that it dovetails nicely with the request for attorney's fees. The plaintiff's counsels are in fact uniquely qualified to make determinations and assessments about the special harms that claimants suffered. And there's a very practical reason for that. Going back to 2015, our firm has handled literally thousands of phone calls. We have created a database with approximately 1,500 people in the database. And this wasn't just fax us in an intake sheet. We interviewed these people. We spoke with them. We created files for them. We talked to them to learn about why their damages were in fact related to the seizures. I'll just take a little dogleg and explain the bankruptcy issue really quickly, and why we may need some extra time and set aside that I'll be talking about later. This was one of the issues that didn't become clear for me for a long time, because I remember talking to claimants and thinking, geez, you're filing for bankruptcy, but that's because you have medical debt, you've got other financial issues in your life that contributed to this bankruptcy. But once we really dug down, we learned what was happening is that the agency was actually going in and filing adverse proceedings in 1,100 bankruptcies. So we have a universe of people who we know filed bankruptcy, and we know the bankruptcy was not discharged because the state filed an adversary proceeding. So again, not to belabor the point, but we've spent a lot of time getting to know these claimants. We've spent a lot of time trying to categorize and articulate the different types of harms that they suffered. Stories that someone was waiting to replace a refrigerator and couldn't do it because their tax refund was seized. I mean, there are hundreds and hundreds of those stories. So I'll go back more directly to our motion for attorney's fees, costs, and a set aside. And I want to directly answer your question, Judge. How do you get those numbers? So we have a gross recovery of $20 million. We have costs as of December 1st that come to $38,664.36. And Your Honor, I personally went through our firm's accounting and cost reporting reports, and it was a mess. It was pages and pages of individual copying fees. And so I reviewed it, I double checked it, I ran it by other people in the firm, and I created that consolidated expense list, which is Exhibit B of or Part B to Exhibit 6 in the attachment. And as I mentioned in the motion, we expect those costs to increase dramatically and quickly. We've now retained the administrator. We're going to start rolling out the notice. And that's why we've asked the court to authorize us to set aside. And by set aside, we mean not allocate to the claimants, not allocate to attorney's fees, just set aside a fund of $500,000. I think Mr. Pitt was speaking earlier and said 1.5 million. We settled on 500,000, and that's what's included in the papers. And again, to kind of collect the loop on some of these things, we don't think that we're going to need $500,000, but we can't be sure when an issue is going to come up and we need to go hire a professor at UCLA to explain something. So we don't want to be caught short. I can certify to the court that we will not collect our attorney's fee until there is final approval. The claimants will be paid up. This court will have approved it. We would like to direct the court's attention to what we think is the prevailing state of the law. And we are asking for an attorney fee based on the recovery of the fund. And that is the method that is recognized by the United States Supreme Court and courts across the country. It stands for the fact that it's well established that counsel who performs a common benefit work is entitled to compensation. And that's Boring v. Van Gemert, 444, United States 472. So once we're moving forward with the concept that we're requesting a percentage of the fund, the Sixth Circuit in Ramey versus Cincinnati Inquirer outlined a series of factors to consider. And I would argue that all of them weigh in favor of approving the plaintiff's request for attorney's fees, for costs, and for a set aside. Factor number one, which courts recognize as the most important, is the value of the benefit rendered. And I don't think that I need to go into this in detail again because it's been covered by my co-counsel, but it was an excellent result. This case, had it not settled, would have been on an extremely complicated path to discovery. And just to give you a glimpse into what that might have looked like, one of the underlying issues here is the use of artificial intelligence in connection with payment of benefits. And so we would actually have to get into extensive discovery of the the companies that developed the algorithm, and we'd have to get counter experts to say why the code that they wrote was insufficient. This is a very expensive, very time-consuming process, and the counsel for the plaintiffs and for the defendant recognized that this was a long haul, multiple years ahead of us if we didn't resolve the case, and that brings very, very, very real value to the claimants. Next is society's stake at rewarding attorneys who take this kind of work. There's no, inherent fee shifting statute, pardon me, to provide a benefit for someone whose constitutional rights have been violated by the state. We not only provided a very real result, but we solidified the state of the law in Michigan, making that a clear damages benefit for someone who suffers a constitutional violation. And I would submit to the court that that's a very real value to society, and that attorneys should be encouraged to go into this type of work, even if they're not pursuing a practice where there's a statute like the Elliott Larson Civil Rights Act that explicitly carves out that fee petition. The services, factor number 3, the services were rendered on a contingency fee basis. We have fee agreements with both Mr. Bauserman and Mr. Bro. The value of the services mitigates in favor of approving the settlement. Again, we have $20 million settlement now versus a $20 million resolution after a trial. We are relying on the state. We're learning that the settlement is for nearly the amount that is going to be paid out. It's hard to imagine a much better result had we waited. Finally, the last 2 factors are the complexity of the litigation. I'm sure you can tell, Your Honor, with going to the Michigan Supreme Court twice, this was very, very complex litigation, cutting edge issues, a lot of time, 7 years. We have 4 partners at Pitt McGee who've been working on this, and many, many other attorneys like Van. And finally, counsel skill level. We have submitted documentation. All of the class counsel have been involved in numerous class actions, have practiced for many, many years, and are skilled and qualified. Thank you.
Well, you guys sure know how to make a record.
I'm sorry, Judge.
No. I was just going to check in with Ms. Taylor and then go on to the next thing, unless you weren't done, Ms. Lord.
It was done with that segment.
All right, very good. Then, well, why don't you proceed, and then I'll check in with Ms. Taylor. Go ahead.
All right, and we're really starting to overlap on all these different topics at this point. The plaintiffs respectfully request that you formally approve Megan Norris as special master. Ms. Norris is uniquely qualified to be special master. She's spent time in the databases already. She has a staff that she's utilized to run reports who are familiar with the different agency databases. So she is not only going to hit the ground running, she is aware of all the issues and can provide excellent value. She has a stunning reputation for many, many years, and she is going to provide an additional assurance that due process is done. We want to make sure that all of the claimants are heard, even if they get a result that they are not happy with. We want everyone to be heard, and she provides that very important purpose. Unless there's any more questions about her qualifications, I will rest.
Very good. Ms. Taylor, any comments or response to anything that Ms. Lord has covered?
Just rather quickly, Your Honor, for the record. In respect to the attorney fee issues, the attorney fees seem reasonable to me, and so I have no objection there. And I would agree with the appointment of Megan Norris. She did an excellent job acting as the mediator in this case. There was a lot of information for her to take in and decipher. And for someone to be able to do that without experience in unemployment law, I tremendous hats off to her. So I believe she is uniquely qualified to act as a special master here and have no objection whatsoever.
All right. Is there anything else on which approval is being requested today? the service award. Yeah, I mean, if you want to comment, say something about that, that's fine. I certainly don't have a problem with it, but feel free.
We don't need to add anything if the court doesn't have any additional questions. It's a modest amount. These two gentlemen were involved in this case for 7 years.
Yep. I understand. Okay.
And I have no objection to that, Your Honor.
Very good. I reviewed all the materials, and it's my intention to sign everything, although I'll go through it again before I do so. My understanding so far is that the only, I think Ms. Rivers said there were a couple of typos in the notice. Was there anything else that anybody anticipates will require correction or change? That sounds like a
No, but yeah, but there's a supplemental issue that occurred to me after we submitted, and that is
okay.
Class counsel are going to be, writing checks, for the administration of the claims process, and we're wondering what the court's preference would be. I mean, in some class actions, every check has to be approved by the court. Other class actions, they put, they allow class counsel to order payments made through the process, and then at the end, at the fairness hearing, at the end of the process, you get a full accounting as to what we pulled from the fund, and you can then approve it, or if there's a clawback required, you can order at that time. So we haven't really addressed that in our papers, and we just want to give the court some reason to think about how much control they want over the day-to-day check writing from the fund.
Well, I don't see any reason for me to oversee check writing so long as I have an accurate accounting at the end and people have an opportunity to raise any issues they wish. Do you want to submit an order to that effect?
Yes, we will do that.
Okay.
We actually have presented, I think, as Exhibit 7, a proposed order that goes through these components. Perhaps we'll submit a revision that includes some language about our authority to write checks to cover administrative costs, if that would be okay with the court.
Yes, as a practical matter, what have you submitted to me for signature that I shouldn't sign yet? If assuming I go through everything and I'm satisfied, is it just I don't have to sign off on the notice itself, right? I mean, I sign off on approving it, but I don't have to. You don't need my signature on the notice, right?
Yeah, there's one omnibus order that we presented to you as Exhibit 7, which establishes the approvals for these various components.
Okay.
If you look at Exhibit 7, you'll see that we've anticipated the court expressing some opinion or approval on each of these categories.
Okay. All right. Well, I do anticipate signing everything at this point. Is there anything else you want or need from me today, and or that you haven't mentioned that I might want to know before I sign approvals on the 19th?
No, we're going to, like I said, we'll submit a revised proposed order that includes the authority to write checks and take it from there.
And that'll be modified in the omnibus order?
Yes.
Okay, so I will wait for that. Very good. Unless there's something else, I'm satisfied with the record that you made here today, and I'll proceed to sign the document once I've received it and conduct a final review. Anything else?
Not from the defendant. Thank you, Your Honor.
Very good. Thank you all very much, and well done. And I'll watch for your order.
Thank you.
Thank you.
Thank you, Your Honor.
Goodbye.